Alimony is a form of money payment from one party to another for support, to pay for items such as housing, utilities, food, and clothing. Alimony is also a form of spousal support. Connecticut General Statutes, Section 46B-82, provides various factors the court will look at in determining an award of alimony. The court will consider several factors in making such an award. While the two primary factors tend to be a spouse's need for support and the other spouse's ability to pay, other factors considered by the court include, first, the length of the marriage; two, the causes of the dissolution of the marriage, legal separation or annulment; three, the age of both spouses; four, the health of both spouses; five, the occupation of both spouses; six, the income of both spouses; seven, the vocational skills of both spouses; eight, employability of both spouses; nine, the combined total estate of the spouses; and 10, the needs of the spouses. The court may order that either of the spouses pay alimony to the other, or that no alimony is paid. This order may be in addition to or in lieu of any property award, as the purpose of a property award is to equally divide the ownership of the spouse's property, while the purpose of alimony is to continue a duty of one spouse to support the other spouse. There are different types of alimony awards. A temporary alimony award, including, also known as pendente lite alimony, is alimony that is awarded and ordered to be paid while the divorce case is pending, so that the more moneyed spouse cannot take undue advantage of their less moneyed spouse. A periodic alimony award is a type of permanent alimony which is paid in scheduled intervals. The purpose of periodic alimony is primarily to continue the duty to support the recipient spouse. The Superior Court may also order that some form of security is given on an award for alimony. This may possibly include, but is by no means limited to, an order that a spouse obtain life insurance as a security to the payment of alimony. In a sense, alimony is like child support because it cannot be discharged in bankruptcy court. Unlike child support, however, the payment of alimony from one spouse to another spouse for that spouse's support may be deductible by the payer on his or her tax return and includable as income to the recipient. Depending on the type of alimony, modifications may also be made based on a material and substantial changes of circumstances unforeseen at the time of the divorce. Finally, individuals who are parties to a civil union will have all of the same benefits, protections, and responsibilities in Connecticut as spouses in a marriage. Consulting with a fellow of the Connecticut Chapter of the American Academy of Matrimonial Lawyers will help you better understand the various alimony options available and the factors the court must consider in making such an award. Across the United States, there exists a broad spectrum of laws, rules, regulations, and procedures that mandate the responsibility of each parent toward the financial support of their children and the enforcement of child support obligations within and across state lines. The basic principle is that both parents are required to share responsibility for the support of their children. Child support may be thought of as a child's right to be protected financially from the acrimony that too often accompanies the divorce process. The child support system is also designed to prevent taxpayer dollars from being used to support the needs of children that can and should be supported from their parents' resources. The duty to support a child exists regardless of whether the child's parents were ever married to each other. So this issue arises in paternity cases as well as in divorce actions. The duty exists and will be enforced by the family courts, in most cases, until the child reaches the age of majority, and may be extended to a higher age if the child remains dependent on parental support and/or is enrolled in a full-time college education program, depending on the jurisdiction. In 1988, Congress enacted the Family Support Act of 1988, mandating that each state establish a set of written guidelines by which the child support orders are to be calculated by 1994. Under this statutory scheme, the level of child support that is calculated under a state's guideline is deemed or considered to be the presumptively correct amount. Additional acts of Congress have continued to enhance and sharpen the child support establishment and enforcement rights and remedies that are available for the protection of the nation's children. One of the more significant enactments was the Full Faith and Credit for Child Support Orders Act of 1994. That law requires each state to enforce a child support order of another state. There is now, as a result of these and other enactments, a more uniform system of establishing and enforcing child support orders across the country. The ultimate goal of the system is to increase compliance with child support orders through maintaining standards by which child support orders are perceived as fair by all involved. The parent's gross income from all sources is the most important factor or variable when child support is calculated. For child support purposes, income is broadly defined. When there is evidence that a parent is not earning as much income as he or she could, the judge considering child support may impute a level of income to that parent to calculate support. Other factors that are typically considered in determining child support are the costs of child care, the cost of health insurance, and in some states, the cost of health expenses not covered by insurance. These expenses may be deducted from the paying parent's income before the child support is calculated. In certain cases, the judge that calculates the support has discretion to deviate from the presumptively correct amount and enter a child support order that is either higher or lower. The reasons for such a deviation can vary, and the burden is on the parent seeking the deviation to prove or convince the judge that an order for the presumptively correct amount of child support would be unjust or inappropriate. Be sure to discuss these options with your lawyer. When a judge decides to deviate from the presumptively correct amount of support, written findings are usually required. There are virtually no circumstances in which a child support order will be set at zero. The level of support at minimum must cover a child's basic subsistence needs. If one or both parents enjoy a high lifestyle, however, in some jurisdictions, the child is generally entitled to share in the benefit of that standard of living. The guidelines in Connecticut set a cap or limit on the highest level of income to which the guidelines are to be applied. This does not necessarily mean that no child support will be paid on income over the cap or limit. In cases involving high income, the judge has discretion to make child support orders based on the particular circumstances of the case and the standard of living maintained by the parents and children. In certain situations, a parent's duty of support may end before a child turns 18 years old or the local age of majority. For example, if a child gets married, enlists in the armed forces, or becomes financially self-supporting, the parent's legal duty to support that child may be deemed at its end. If the child has long-term disabilities, the support may extend into the future. In addition to child support, each parent may be required to contribute to a child's medical health expenses, daycare, education costs, and extracurricular activity fees and expenses. Many states give consideration to these other sorts of add-on expenses when calculating child support. The allocation of certain costs and expenses may be mandatory, depending upon the state's guidelines, or may be a matter within the judge's discretion. In Connecticut, parties can also be required to pay the cost of the child to attend college, although they cannot be required to pay more than the cost for the child to attend the University of Connecticut. Parents are often encouraged to make settlement or separation agreements in divorce cases. Agreements that involve child support, however, must be reviewed by the judge and approved before they may be enforced. This supervision by the courts is necessary because the parents do not have the right to bargain away a child's right to receive appropriate financial support from both of the parents. When more than one child is being supported, the support order will generally be higher. The ages of the children and the particular needs of older children can be factors in a given case. Also, the manner in which the parents share custody of the children, for example, sole custody, equally shared custody, or split custody, or the proportion of time that the children spend with each parent are factors that may be implicated when setting a child support order. When a material change of circumstances has occurred with the parents or the child, a child support order may be modified by a subsequent court order. The parent seeking the change bears the burden of proving that changed circumstances justify a change. The change may be reduced child support in recognition of a loss of income, or it may be an increase in support due to a substantial income increase. Child support should never be withheld or delayed as a means of getting back at an estranged or former spouse. On the other hand, a child should never be denied access to a parent on the sole grounds that the parent is behind in his or her support obligation. Child support guidelines are designed to be used to encourage the involvement of both parents in the child's upbringing. Child support is just one aspect of what is in a child's overall best interests. All states have statutes, rules, and procedures for enforcing both child support and custodial rights that have been denied or withheld. Government agencies, both federal and state, are available to help enforce child support orders and collect unpaid child support. A parent's resort to self-help in such circumstances is therefore not appropriate.